Hello, everyone. I'm Judge Steven Teske, retired, and this is the Teske Brief. Now, in this series titled The Bar Card and the Breakdown of Justice, we examine one of the most important stories in American law and government today, and it's this. What happens when the lawyers entrusted to enforce justice begin to fear the very system that they serve? Now, across this series, we've been exploring and will continue to explore why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, and why independent courts and state bars still matter, and what is lost when institutions ask for power but stop earning trust. This is not a story about personalities alone. It is a story about professional duty, constitutional guardrails, and whether the rule of law can withstand the pressures placed upon it. This is episode 5, and it's titled Target First, Crime Later. But before we begin, remember, titles are temporary, power is borrowed, integrity is tested when pressures arise, and this is the Teske Brief. Welcome back. There's a phrase that should terrify anyone who believes in the rule of law. Target first, crime later. Because once that becomes the method, the justice system stops acting like a referee and starts acting like a hitman with paperwork. In a normal legal system, the process is supposed to be simple. You investigate conduct, you gather facts, you determine whether a law was broken, and only then do you ask, well, who did it? That's the order. It's not complicated. It's not radical. It's basically law enforcement for adults. And this warning is not new. I've shared this before in previous episodes. Way back in 1940, Attorney General Robert Jackson, who would later become Supreme Court Justice Robert Jackson, warned federal prosecutors about what he called the most dangerous power that they possess. The power to pick people they think they should get rather than pick cases that need to be prosecuted. That was about 86 years ago. And somehow it still sounds like tomorrow's headline. But in a target first system, the order flips. First comes, who do we want? Then comes, what can we charge them with? And then, can we stretch this statute? Can we pressure a witness? Can we announce an investigation before we actually have a case? Can we make the process painful enough that the result almost doesn't matter? And just like that, justice becomes reverse engineered. It's like deciding who should win the Super Bowl and then asking the refs to get creative. Now, nobody announces this out loud, right? There's no press conference that says, good afternoon, we are abandoning neutrality effective immediately. No memo goes out titled Operation Get That Guy. It happens more quietly. A politician names an enemy, cable news gets angry, somebody says we should look into this, and suddenly 20 people are in a conference room trying to turn vibes into probable cause. We've seen versions of this play out in public. Investigations launch with dramatic headlines, and then they're dropped, just like that. Charges filed, then dismissed. Judges asking whether the government actually had evidence or simply had a target in mind. The Jerome Powell probe is one example. Huge public drama, subpoenas, threats, and then no evidence of a crime. Which means somewhere, a lot of people spend a lot of taxpayer money investigating the federal offense of being inconvenient.
I wonder, Catherine, what does this tell you about the strength of the case the prosecutors had? Would they be closing it if they had actual evidence of any criminal wrongdoing, do you think?
No, and it's everything Ken said. And Jeanine Pirro knows better. She was a district attorney in New York for many years. As a prosecutor, you do not open a criminal investigation unless you have a good faith basis to believe that a crime has been committed. And that clearly was not in this case. And it was the ethical thing to do for her to close it, though she adds a zinger in her statement that you might reopen it if the facts warrant. Well, yes, if there are facts that she suddenly finds that there's crimes been committed, yes, that would be appropriate. But this should have never been a criminal investigation.
A recent case illustrates the danger in real time. You take the Justice Department, who secured an indictment against former FBI Director James Comey based on a social media post that is showing seashells arranged in the numbers 8647. Prosecutors characterized the image as a threat against the president, interpreting 86 to mean kill. But the phrase 86 is widely used in ordinary speech to mean remove or cancel or cut off. It appears on merchandise and political slogans and in everyday conversation across the country. My God, just go on Amazon and in its search engine put 8647 shirts, and they'll have all these shirts with 8647 that you can buy. You can even put in 8646 for Biden. People wore these as a protest to that president at that time. Okay? I mean, are we going after, are subpoenas being sent to Amazon? Who's purchased these shirts so we can go and prosecute them? No, that's not happening. We call that selective prosecution, or selective persecution, as I like to say it. Even critics of Mr. Comey have questioned whether such an ambiguous expression could reasonably be understood as a serious threat of violence. That ambiguity is not a minor detail. It is a case.
Speaking of prosecutions, the Justice Department indicted former FBI Director James Comey again, this time for posting a photograph on Instagram of seashells spelling out 8647. 47, obviously, Donald Trump is the 47th presidency. Here's what President Trump had to say about that.
Well, if anybody knows anything about crime, they know 86. You know what 86? It's a mob term for kill 'em. You know, you ever see the movies? 86 'em. The mobster says to one of his wonderful associates, 86 'em. That means kill 'em.
Do you think posting 8647 is a crime?
No, again, if this prosecution, which is coming from the Eastern District of North Carolina, if this whole case is based on a picture in the sand of a North Carolina beach, it again makes no sense to me. Number one, 86, I used to work in the restaurant industry, and I think 86 actually has its roots as a cook.
That's my understanding too. Yeah.
It has its roots in 86ing the menu or 86ing the product. I can't find any evidence except some that's come up after the president made the comment about the movies. I know the penal code in North Carolina, 187, means murder, but I can't find any evidence where 86 is used as a call for violence.
Because criminal prosecution, particularly one implicating speech, requires more than a strained interpretation. It requires evidence of intent, context, and a factual basis sufficient to distinguish protected expression from unlawful conduct. Without that, the prosecution risks collapsing into something else, an effort to assign criminal meaning after the target has already been chosen. The broader context only sharpens the concern. Reporting indicates that the indictment emerged amid internal pressure to pursue cases against individuals viewed as political adversaries of the president, with officials operating in an environment where satisfying leadership expectations may outweigh traditional prosecutorial caution, that is, the rules of ethics. If that is true, the case does not merely test the limits of legal interpretation. It illustrates the very danger Justice Robert Jackson warned about. When prosecutors select a person first and search for an offense second, the process ceases to be an instrument of justice and becomes an exercise of power. And once that standard is accepted, it does not remain confined to one defendant, folks. It applies to everyone. And here's the trick. Even failed cases can succeed politically because the arrest happens first. The handcuffs, the headline happens first. The mugshot happens first. The cable news siren happens first. The dismissal, that's page 12, below an article about competitive gardening. So if your real goal is humiliation, distraction, or retaliation, you may not need to win in court at all. You just need to start the process.
Brian, I am not rooting for Donald Trump's dirty DOJ or Ed Stop the Steal Martin, we'll talk about him in a minute, to bring a vindictive prosecution against anybody. Nobody should have to, suffer having to hire lawyers, pay a bunch of money, spend time in court, only to have a bogus case, a vindictive case against them, thrown out, dismissed with prejudice by a judge. However, I am almost looking forward to the day that Donald Trump's dirty DOJ indicts someone vindictively, because then it's on. And I suspect any self-respecting federal judge, indeed, I'm going to go out on a limb and say any federal court judge in any jurisdiction in the country, with the exception of Aileen Cannon, would cram a vindictive prosecution down the throat of the DOJ lawyer who was unethical enough to bring it. So,
but Glenn, if we know that vindictive prosecution is a defense against what may very well be a vindictive prosecution, why is Ed Martin coming out and parading this around, offering up this defense on a silver platter to Adam Schiff? Is it because he knows that there's no there, and so really, at the end of the day, his only goal is to kind of prosecute this case in the court of public opinion, to paint Adam Schiff as some nefarious actor, knowing full well that when he gets into the courtroom, no judge is going to bite?
Of course, he is taking a page out of Donald Trump's dirty playbook. Just announce the investigations and poison the well of public opinion against Adam Schiff or whoever the Trump enemy du jour is. I do not believe there will be a prosecution against Adam Schiff or any of Donald Trump's other announced enemies. We can go back 10 years. He was going to prosecute Hillary Clinton, lock her up. Remember that chant? And 10 years later, she hasn't been indicted, prosecuted for anything. Donald Trump doesn't intend to prosecute people. He intends to announce criminal investigations and just let that permeate the public's consciousness.
And folks, that's why this matters. Because prosecutors are supposed to test suspicion, not ratify it. They're supposed to ask, do the facts support this case? Not, can we make this person miserable by Thursday? That difference is the line between justice and abuse. Now, some people hear criticism like this and say, well, so powerful people should get away with everything? No, absolutely not. No one is above the law. But here's the part they skip. No one is beneath its protections either. The same evidence, the same standards, the same fairness for allies, enemies, celebrities, nobodies, and that guy yelling in the Facebook comments. That's equal justice. And once target first tactics become normal, they never stay limited. Tools built for enemies get used on rivals. Shortcuts taken in dramatic cases show up in ordinary ones. Today it's someone famous, tomorrow it's someone forgettable. Authoritarian habits always start with exceptions. Then they become policy. The Department of Justice has enormous power. It can take liberty, it can take money, it can ruin your reputation and years of your life. That's why it must begin with evidence, not appetite. Crime first, facts first, law first, then the person. That's the way it's supposed to work. Reverse that order, and the public stops seeing prosecutions as justice. They start seeing them as power plays with subpoenas. Look, Justice Robert Jackson warned us long ago, right? The danger was never theoretical. The only question now is whether we listened. All right, folks, I'm Judge Steven Teske, retired, and this is the Teske Brief. Remember this, justice begins with facts. When it begins with enemies, it's something else entirely. Until the next episode, everyone, be safe and take care. Bye.